So you're thinking about suing someone. You've probably got a million questions, but there's one that sits right at the top of the pile. How much is my case actually worth? Getting this number right isn't just important. It is one of the most critical decisions you will make, and it can literally shape the entire outcome of your case. Let's break down how it all works.
And if you're filing that lawsuit here in Ontario, this is an absolute make or break moment. The system requires you, it demands that you put a specific dollar figure on your claim from the get-go. And if you aim too high, or maybe even too low, the consequences can be really, really severe. This isn't just about picking a number out of a hat. It's a strategic first step that sets the stage for everything that comes next.
Okay, let's dive into the first major topic here, stating your claim's value. You can honestly think of this as the first and maybe the most important rule of the game. It's non-negotiable. And the law couldn't be more direct about this. Here it is, straight from the Ontario Rules of Civil Procedure. Rule 25.06 says, the amount claimed for each claimant shall be stated. There's no gray area here, no wiggle room. You have to name your number. So to put all that legal jargon into plain English, your very first task when you file that lawsuit is to put down a specific dollar amount you're asking for. You can't just say a lot of money or whatever the judge thinks is fair. Nope. You have to pick a number. But it gets a little more complicated from there. You can't just slap one big number on the page and call it a day. The rules actually force you to break it all down. So let's look at the two main categories the law uses for your damages. And first, a quick definition so we're all on the same page. You're going to hear lawyers talk about pleading. All that means is the formal documents, like your statement of claim, that officially kick off the case. It's where you lay out your side of the story and tell the court exactly what you want. Think of it as the foundation for your entire lawsuit. And this is where we get those two key categories of damages. On one side, you've got special damages. The easiest way to think about these is that they're the receipt-based losses, the stuff you can calculate right down to the penny, like lost wages, physiotherapy bills, or car repairs. Then, on the other side, you have general damages. Now, these are the things that don't have a clear price tag, right? Like pain and suffering or emotional distress. In these cases, it's up to the court to figure out what's fair based on your situation and what other people have gotten in similar cases. Now, for those special damages, the ones with the paper trail, it's an ongoing job. You have to list every cost you know about when you first file your claim, but it doesn't stop there. As new bills come in, you are legally required to provide updates to the other side. This is why keeping meticulous records is so crucial, because you have to deliver that final, complete list at least 10 days before the trial even starts. Okay, so we've covered the basics of how you have to state your claim. Now let's get into a couple of special calculations that can seriously increase that final number. We're talking about interest and future losses. This is a huge one, particularly in personal injury cases. The law gets that if you've been hurt, you've been waiting, sometimes for years, to get compensation. So to make up for that delay, the rules automatically add a specific interest rate to the pain and suffering part of your award. And what is that rate? Well, according to Rule 53.1, it's a flat 5% per year. It's simple, it's predictable, and believe me, over the life of a long lawsuit, that can really, really add up. Okay, but what about money you expect to lose down the road? Say an injury means you can't work for the next 30 years, or you're going to need medical care for the rest of your life. How on earth do you calculate that? Well, you don't just guess. The rules actually provide a specific formula to figure out the present-day value of all those future losses. Now, I know this table looks a bit technical, but hang with me. Rule 53.09 gives us something called a discount rate. Just think of it like this. It's how much money you would need in a lump sum today to cover all your future costs, assuming you could invest it. And as you can see, the law has a two-part system. One rate for the first 15 years, and then a fixed 2.5% rate for any time after that. The big takeaway here is that this isn't random. It's a precise calculation that the rules require. So far, we've talked all about how to calculate your claim. Now let's talk about why getting that number right is so incredibly important. Because there are some very high costs for aiming wrong, especially when it comes to picking which court to file your lawsuit in. So let's imagine a really common situation. In Ontario, you've got two main courts for this stuff. Small Claims Court for smaller cases, and then the Superior Court of Justice for the bigger ones. So what happens if you overestimate your case value and you sue in the big leagues, Superior Court, but the judge eventually decides your case really belonged down in small claims? Well, the answer can be a real punch to the gut. Rule 57.05 gives the court a pretty powerful tool here. It says the court may order that the plaintiff shall not recover any costs. Just let that sink in for a second.
This shows you the huge risk you're taking if you aim too high. It means you could go through the whole stressful, expensive lawsuit, you could prove your case, you could win, and then the judge could turn around and say you're not getting a dime back for your legal bills. You'd get your damages, sure, but you could lose a massive chunk of it, or maybe even all of it, to your own lawyer. It's the kind of victory that feels an awful lot like a loss.
So as we wrap this up, it's pretty clear that the number you write on that statement of claim is so much more than just a number. It's a critical, strategic decision that impacts everything from your interest calculations to the court you end up in, and ultimately how much money you actually walk away with. The real question for anyone starting this process is, are you absolutely sure you're aiming for the right target?